Hello from Houston, Texas. My name is Emily Newman, and I'm an immigration attorney with Reddy & Newman PC, and I'm here with my partner, Rahul Reddy, who's also an immigration attorney. We are doing Facebook Live today to give you some updates on the H-1B filing window that opened yesterday, and to answer your questions on that. So I guess we'll start off with the number one question. How many applications are going to be filed, do you think?
I think so. It's going to be less than last year, Emily, as we have noticed that the number of applications in our office have gone down. At the same time, when you look into the feeling in the society, it seems that the application numbers have gone down. But I don't think so they've gone down significantly. I think so they might have gone down maybe 5 to 10%. That is my guess. What do you say, Emily?
Yeah, I would agree with that. I think, you know, a lot of people are saying, oh, companies aren't filing. Maybe certain companies aren't filing, but others are. We also, just think about the number of applications last year, 199,000. We know for sure at least 99,000 didn't get selected. More than that got denied, revoked, withdrawn, whatever happened. So we have a good number of people, enough people that didn't make it last year to fill the whole cap this year, not even counting the new graduates, new petitions, new people that haven't filed before. So I do think that we're going to have less than last year, but not a whole lot less.
We noticed, Emily, that the February 22nd memo with regards to the end client letters, where if the person is working at a third-party location, the USCIS have taken a very stricter standard with regards to how they are going to approve the H-1B, particularly if the end client letter is not there, the vendor letter is not there, and if the end client letter is not in the proper format. Is it true that they're going to deny the application without even looking into the application when the end client letter is missing in the H-1B application?
No, I think they're always going to send a request for evidence for any documents like that they need to make a decision. So it's always good to have it in the initial filing, but it's not mandatory. You could file without and just be prepared to provide it at the time of an RFE.
Emily, a lot of people are not aware of, and I just want to make sure that you make everybody aware. Can they travel when the H-1B is pending, when they apply for change of status from F1 to H-1B, between the period of April and October?
Well, I guess there's two questions there. Can they or should they?
Okay.
Can they? Sure, you can always travel. Should you? No, absolutely not. If you have requested a change of status from F1 to H1 or any other status, L1 to H1, H4 to H1, anything else, if you leave the country while a change of status is pending, it's going to be automatically abandoned. Now, no, that doesn't mean the petition itself will be abandoned, but your request to change status will be abandoned, which means you'll be approved without an I-94 card. You've got to get the visa stamp before you can come back and work in H-1B status. Now, a lot of students say, hey, I have a valid F1 visa, I have an OPT, can't I go out and come back in under the Hernandez memo? What do you say to that?
No, the last action rule is what they are speaking about. However, it has a lot of complications in it. Is that when the person comes back into the United States, if the USCIS adjudicates the H-1B, they do give an old I-94 number because the I-94 is not valid. They don't update the new I-94 number. Even though the last action rule is applicable, the system, USCIS system, does not have a method to recognize the last action rule. So it's going to throw out the whole system out. It's going to confuse the whole system, and it's going to cause a lot of problem. Also, I want to reiterate that the Trump administration has issued that every time a person is entering into United States, they're going to check into if the intent of the person is accurate or not. Particularly if you are an F1 visa, you are an OPT or STEM extension, you're trying to come back, your intention should only be to temporarily stay in United States. And if you applied for H-1B, that shows that you want to stay here on a long term on a work visa. Now that is contradicting the F1 stay, which you have to go back after your period of stay ends. So that is contradicting, and you might be thrown out of the country completely. So I do not want these people to risk traveling outside the country while the H-1B is pending.
All right. Question on H-4 EAD. If your H-4 EAD has expired and you filed for the renewal, can you keep working?
No. If the H-4 EAD is expired, you cannot work. Even if your H-4 EAD extension is pending, you cannot work. You have to cease working. Emily, that is another question. You have been publishing articles and doing all the survey on the H-4 EADs. What do you think is going to happen to the H-4 EAD now? Is it going to be there? Is it going to be not be existing in future?
Well, it's certainly there now. It's going to continue to be there for the near future. We're expecting a proposed regulation sometime in June that would possibly repeal or vacate the previous regulation that created it. Now that won't happen immediately. It won't take effect right away. It's just a proposal. Once a regulation is proposed, it's going to take months and months for the comment period, for the government to figure out whether they still want to proceed with that route, whether the comments, all the comments have to be taken into consideration. Then if they finally decide, yes, we still want to proceed with this option, then they'll issue a final rule that's going to take another 2 months or so before it can actually take effect. So nothing's going to happen overnight. And I would expect, even if they try it, there's going to be litigation for sure.
Yeah, there's going to be litigation. So most probably, I'm expecting that the H-4 EAD might be there at the end of this year. What do you say?
I would assume so, yeah.
Okay.
And let me just say, DACA, do you know you can still file DACA? But Trump ended the program, right?
Wow, what happened if Trump ended the program?
Litigation.
Litigation. So the courts are allowing the people to file the DACA. Okay, so and they can file the extension. So that could happen with the H-4 EAD also. But at this point of time, H-4 EAD is still active. If you are eligible for the H-4 EAD, please do file for H-4 EAD. And if you are eligible for H-4 EAD extension, you do file for H-4 EAD extension. And those people who are on H-1B, if you are eligible to convert into H-4 EAD, you can convert into H-4 EAD when and if the H-4 EAD gets cancelled. At that point of time, you can choose to come back on the H-1B. Absolutely no problem. And on the H-4 EAD, you could apply for the I-140. Nothing is preventing you to apply for I-140 and H-4 EAD. A lot of people don't know that. They think so that they can't apply for I-140 on the H-4.
All right, we have a question about kind of how long it takes for an approval notice to come in the mail after an extension for an H-1B is approved.
It typically takes about 7 working days to about 10 working days for the H-1 approval to come into the office or to the company's address though. And if it takes longer period of time, maybe 15-20 days, but if it takes longer than that, it would be better that the lawyer or the company contact the USCIS. Particularly in premium processing, they do service a little bit faster. If it's not, it might take a little bit longer time in getting the approval from the USCIS. And if they don't still respond to you, you could still file a duplicate approval request, and that might take approximately 6 months for you to get it though.
All right, one of the questions I see on my blog a lot about the H-1B cap is, why does my LCA start in September? Shouldn't it start on October 1st? Did my lawyer mess up?
Good question. When you file the LCA will not allow the lawyers or the companies to file more than 6 months in advance. So if I were to file a H-1B with October 1st start date, and I'm filing the H-1B LCA on March 1st, I could not put October 1st. I would probably put September 1st. Though the LCA start date is September 1st, that does not prevent the company or the lawyer to put the start date of the H-1B application as October 1st when they are filing under the new quota. Not only that it will allow the lawyers and employees to put the October 1st, if by any chance they put any other date other than October 1st. In other words, if they put September 30th as a start date on the H-1B, it will be denied. However, even though the LCA says September 1st start date, if the H-1B start date is October 1st, they will not deny the H-1B application for that reason. Absolutely they will not. And technically speaking of, most of the LCAs will have a start date before October 1st. If not all, most of them will have before October 1st start date. That's not a problem at all.
All right. Sneha has a question about having a previous H-1B and then changing status to H-4. Can you switch back to H-1B? Do you have to go through the lottery? What's the process for that?
Good question. You could move back to H-1B. If you have any time left over in the 6 years H-1B, you could any time after 2 years, 3 years, 4 years can move back to H-1B. Absolutely no problem. I would also advise you, Sneha, one other thing. If you have not applied for I-140 at the time when you're an H-1B, you could still apply the I-140 on the H-4 EAD. And even if you're H-1B, you might have used most of your time. With that I-140 approval while you are on H-4 EAD, you can use that to extend the H1 to file the H-1B and extend beyond 6 years. So it's advisable for you to apply for I-140 on H-4 EAD even though you're not an H-1B.
Here's one of your favorite questions right now from Karthik. Is it a good time to go for stamping?
No. Please do not go for stamping. And believe me, every single day we get calls, blogs, and all different things saying that I got stuck in India. Do not go for stamping. Please try to avoid, if you can, please do not go for stamping. Even though if you're eligible for the Dropbox, we have noticed that they have been calling the people for the interview from the Dropbox and issuing 221Gs. The problem with the stamping is the way the administration want to harass the immigrants is by delaying the H-1B there. So if you have a job, for example, with a very nice company, and you go there for stamping, and they will put a 221G saying that we're going to inquire more into the details of the H-1B. By the time they complete their investigation, it'll take 4 to 6 months sometimes. But your employer's job won't wait for 4 to 6 months. So then you will be forceful. You're forced to withdraw your own H-1B without the consulate adjudicating, because if you don't have a job, they're going to deny it anyway. There's no purpose for you to get the stamping. Now they come to the Congress and they tell that, look, they filed the H-1Bs, they voluntarily withdraw by themselves. We did not withdraw, denied those things. So be careful when you're going for stamping. I mean, these are all the things we face every day. If you can avoid it, please avoid it. Don't go for stamping.
All right. Sharish has a question about the 240-day rule. First, what is the 240-day rule? And second, what can you do when you're about to cross 240 days?
The H-1B extension says that if your H-1B I-94 has expired, and if your company files a H-1B extension, you could work with the company with the receipt notice. You don't need the approval to work with the company when they file the extension. However, the rule limits that you can only work up to 240 days with the extension receipt notice. But if it crosses the 240 days, you might want to consult a lawyer. They might want to file one more extension to keep you allowed to work beyond the 240 days. We would strongly recommend that you file a premium processing, get the resolution done, so that you don't go beyond 240 days. Emily, does this 240 days, when the H-1B is pending, is it applicable for the transfer or is it only for the extension?
Right, this is only for an extension with the same employer. So the transfer, that is governed by a different piece of legislation under AC 21 portability, which does not have a limit. So when you file a transfer to another employer, your ability to keep working for that new employer continues forever as long as the extension and the transfer to that new employer remains pending. Once it's approved, obviously you continue until the end of the approval, or if it gets denied, then you have to stop. But there is no 240-day rule when it comes to H-1B transfers.
Emily, you brought another important thing. Is the premium processing is suspended? Is it suspended forever? Or can you explain more about what happened with the premium processing? Can you compare that with the last year to this year so that the people will understand much better what happened right now?
Right. We do know that premium processing is suspended only for the cap subject H-1Bs, not for extensions, not for transfers, not for amendments, not for consular processing that's not subject to the cap, not for cap exempt employers. It's only for the cap subject H-1Bs filing in the lottery this week. Those are the only cases that are not allowed to do premium processing. Now compare this to a year ago when we were all blindsided by USCIS announcement that they were going to suspend premium processing for everyone as of April 2nd or April 1st, if I recall correctly. So everyone had to hurry up and upgrade to premium processing for anything they had pending right before the cap season opened up. And then we were not able to upgrade anything to premium or file anything into premium until almost September, October last year for all types of cases. This time around, again, it's just the cap subject H-1Bs that cannot do premium processing. Most likely that will be back around mid-September. Not great timing because especially for those that are on student visas, if you are in the cap gap, your cap gap work authorization ends on September 30th, so it's really important that your H-1B be approved by September 30th so you can continue working without any gap starting on October 1st. Unfortunately, when the H-1B petition for those that are filing a change of status from F1 to H1 who qualify for the cap gap to keep working, once that H-1 crosses October 1st and it's still pending, the cap gap work authorization ends, you have to stop working until the H-1B gets approved. So it's not great news for those that are going to be stuck in the cap gap this year. Hopefully they will improve their processing times, so at least we can see some approvals throughout the summer, but I wouldn't bet on it.
Emily, you have been publishing blogs after the quota time every year from past 2-3 years. When the quota is over, how much percentage of receipt notices have been coming, and when they are coming into the master's quota, bachelor's quota. You've been publishing statistics every day on your blog, Immigration Girl. Are you expected to do the same thing this year? Because a lot of people would like to know if their H-1B selected, what are the probabilities, what are the odds, and they're living and sleeping based on the numbers. Though, would you do it? Can you explain how do you do that? How do you publicize that? Where do you get the stats?
Right. So yes, I do plan on doing it this year. I'm a little bit behind. We're doing some data entry on our cases that we're filing this week. And so once we have the data put together regarding the number of cases we're filing in the advanced degree cap versus regular cap, Vermont Service Center versus California Service Center, I'll be publishing statistics about that based on a percentage. I'm not going to be stating exactly how many petitions we filed in each different category, but we do have a relatively large enough sample size to where the statistics are pretty good indication of what's happening overall. So once we start seeing receipt notices or filing fee checks getting cashed, I'll definitely be posting about that, and then I'll let you know the progress every day, how many are coming in, what percentage have received receipts, what percentage haven't. Going forward with approvals, we'll be doing the same thing. Last year, everything seemed like it was still pending in October, September, we still had cases pending in January, February, March, April. We got an approval today from last year. So it was a little more difficult to post the approval statistics this past year compared to previous years, because in previous years almost everything was done by October 1st. So we'll have to wait and see how it goes this year. I'll do my best to keep that data available for you, just so you can have an idea of where you stand compared to where everybody else is, when you might expect to get a receipt, when you might expect to get a returned petition if it wasn't selected, when you might expect to get an approval notice. All of those things you can find based on what we're seeing in our office on our actual cases.
I'm on questions from Puneet. I'm on H1B and my perm is in progress. I have only 4 months left. Can I move to L2 EAD, and once my I-140 is approved, can I move back to H1B?
Yes, I don't see any problem with that, assuming your spouse is on L1. But other than that, yes. So once you're in H1, you're counted against the cap, so you can leave H1, go to a different status, and switch back to H1 anytime once you have your I-140 approved. It's very possible with 4 months left, you might be able to get the perm and I-140 approved in time and not need to do that, but it's nice to have that backup plan.
My wife has used up 2 years of this is question from Ankur, my wife has used up 2 years of H1B and now she's on H4. Can we switch back to the H1B, and what is the process involved in it?
Yes, so once you're counted in the cap, you've been counted, you don't have to go through it again, so she is eligible for a change of status back to H1B. Now keep in mind, she cannot work until the H1B gets approved, unless of course she has an H4 EAD. So that means we highly recommend filing that in premium processing so that you can get the approval within 15 days and be able to start working right away.
Rupak has a good question, and a lot of people are under the belief that if you do the premium processing, you are going to absolutely get the denial and RFE. And Rupak probably is one of that person. He's telling, I have 3 months of I-140, I-94 left, and my extension is pending. Should I go for premium processing?
Yes, absolutely. 3 months is way too close. So without premium processing, your I-94 is going to expire. You might not be able to renew your driver's license from that point, especially if you're in Texas. Many other states follow the same rules on that. Absolutely, file it in premium processing, upgrade it to premium processing, get the result before your I-94 expires.
Why would they need to get the results before I-94? What's the difference if they get the results after and before, Emily?
Now, if it's approved, there's no difference.
Okay.
The issue is, we know there's a lot more denials, we know there's a lot more RFEs happening right now. If you get a denial before your I-94 expires, you have much more options. You can refile, you can file a transfer, you can change status, file a change of status, all of that because your I-94 is not expired yet. If you get a denial of the extension after your I-94 expires, you're immediately out of status, immediately accruing unlawful presence. It's very difficult to get back into status once you get to that point without leaving the country. So we would highly recommend file your extension in premium processing. Even if it's 6 months early, file it in premium processing. Processing times are not good right now.
Sunil has a question. What about going to Canada or Mexico for stamping? I have a good track record. Keep the record like that, Sunil. Keep the record like that. Don't mess it up. Canada and Mexico are not any good options nowadays. We're seeing a lot of denials. If you don't have a good track record, it's a one-way ticket. If you have a good track record, there is a possibility that you will get the approval. Well, I will not try to take that possibility if I were you. I worked hard to come into the United States, worked hard to get to this H1B. I don't want to get stuck outside the country. My advice to you, Sunil, is don't go for stamping. Please don't go for stamping.
The captain of the Titanic had a great track record too.
Okay, what happened to Titanic, Emily?
Obviously it sank, so just because things have been good so far does not mean that you're guaranteed that they'll be great going forward.
I thought the title of Titanic is, it's unsinkable.
Exactly.
Okay.
Somebody had a question, Srinivas, about the date on the provisional degree certificate compared to the date of the actual degree certificate. Has that caused a problem in I-140s before?
Yeah, it did. It did cause the problems, but we were able to explain to the USCIS what a provisional certificate is, what the convocation certificate is, and I, being a lawyer from both the countries, I'm a licensed lawyer in India, I'm a licensed lawyer in the United States too. I have a law degree there and a law degree here too in the United States. So I was able to sign an affidavit because I know I'm a lawyer in India, I know the circumstances they work. And we were able to successfully get those things approved. There are some cases where we have noticed that where the lawyers were not aware how the degrees are issued in India. They got the denials, but we were able to file with the same I-140, with the same labor certification, we were able to get it. The provisional certificate is issued as soon as the degree has been completed. The convocation certificate is issued either 1 year, 2 years, 3 years, or sometimes even 5 years if the guy does not apply after the degree has been obtained. But your degree obtained is actually on the day you completed your degree, which will be your provisional degree, not on the time when you got the convocation. For example, if you completed your engineering degree in 2014 and you got the convocation in 2016, the degree completion that you have done is 2014. Shouldn't be much problem, but sometimes the officers are new, particularly in Nebraska Service Center. They do ask those questions, but we should be able to be comfortable in that area.
All right. Praveen has a question about dormant H-1Bs. So he had been working for Company A, filed a transfer to Company B, got it approved, never joined Company B, still with A, and now he wants to join Company B. Can he do it? What does he have to file another transfer? Does he have to go for stamping? How do you do that?
Assuming that you have never traveled outside the country after your Company B's H-1B approval is there, assuming that you're going to join at the same end client location or whatever location Company B has been provisioned in the H-1B, assuming that the Company B has not withdrawn the H-1B, yes, you can join the Company B. Not an issue at all. For the safety of the Company B, I would always like to get a letter from the employee indicating that I was working with Company A, I did not join for Company B until this point. That's just for the safety of Company B. But I don't see any issues Praveen joining Company B at a later time if all the conditions which I said are met.
So Saurav kind of has a similar question on that. Is it a problem if you filed a transfer and got it approved but never joined the new company?
No, you're just reading the immigration lawyers. Nothing wrong with it. It's nothing, you're not doing anything illegal for sure, I can tell that. My 797 is valid until February 2019, but my H-1B visa stamping is valid until April 2018. When should I start applying for renewal?
Sorry, I was reading.
I'm sorry. The 797 is valid until February 2019, but my visa stamping is only valid until April 2018. When should I start my renewal?
So the visa stamp, once you're in the United States, is technically no longer relevant. It's not the visa stamp that determines how long you can stay in the country. It's your I-94. So once you're in the U.S., if you have the I-94 that's valid till February 2019, you don't need to take any action until 6 months before February 2019, regardless of whether your visa stamp has expired.
My I-94 and 6 years are expiring in August of 2018. And I-140 is pending. Should I go in premium? Yes, Krishna. I don't see any reason why you're not doing premium processing in I-140. I mean, you don't want to take any chance. You want to get the I-140 approval. Not only that, I would like you to file a premium processing H-1B once the I-140 is approved, because you don't even want to wait until August to get the result. As Emily was pointing out, there'll be a lot of different options. So you better get the I-140 in premium processing. You get the H-1B in premium processing. Absolutely no reason to wait.
All right. Brajesh was asking what are the main reasons for RFEs or denials for an H-1B extension. Specialty occupation is probably the number one. Beneficiary qualifications, even though you've already been approved for an H-1B, who knows how many times before all of a sudden they're questioning whether you qualify for it. Employer-employee relationship, if you're dealing with third-party placement. Availability of sufficient specialty occupation work. Basically, they want to ensure that there's enough work available for you for the full period that you're requesting. So they'll often ask for company tax returns, marketing materials, cost analysis to make sure that you're not going to run out of work after 1 year.
Well, I got your point, Emily, but I might want to suggest the audience is a different thing. There's only one reason according to me, that is Trump. That is it. I mean, that's the whole administration has changed the strategy with regards to it. For example, system analyst position, historically it was getting, mostly approved for all period of time. Since the time our office has been existing from April 1st of 1997, it's been 21 years. But all of a sudden, from November of 2017, they started denying the applications. So most of what Emily has pointed out, it's been more strictly implemented since the Trump came into being, not before that. Emily, what do you think? So this EB3, EB2, now EB3 is more forward than EB2 for Indian nationals. What do you think so the movement is going to be? That's the question. And also, what do you think so the priority date movements are going to be? Neelish is asking the same question. A couple of other people is asking the same question.
Well, unfortunately, there's not going to be a lot of movement, and I think the EB3, EB2 interplay is going to be similar to what we saw happening in China, to where at some point EB3 was a better priority date, so people downgraded to EB3, and then EB2 started getting faster, people upgraded to EB2, people are filing 2 I-140s, one in EB3 and one in EB2 to go with whichever one happens first, and it just keeps flip-flopping back and forth. And I think India might be headed in that direction as well.
I could say one thing, that for those people who are applying for the green card right now, and for those people who are in the pipeline though, for those people who are applying for the green card right now, based on the current statistics and current applications, if the things run as they are, no changes in the legislation, you are not getting the green card. And for those people who are waiting for the priority date to become current, just for you guys to cross the May 2010, which is when it was current in 2012 for a period of time until May of 2010. By the time the priority dates for EB2 crosses May of 2010, it's going to take about 8 years for you guys to get the moment though. So depending on where you stand at, starting from May 2010, it might take a couple of different years. I have written a very good article on rnlawgroup.com, how much time it takes for you to get the green card. I pulled out all the statistics from the Department of Labor and the USCIS, and that will determine, you can look into those things. You might not be able to read them very properly, but I have put it in a proper article to guess what time it's going to take for you to get the green card. Particularly if you're Indian national. Obviously, if you're not Indian national, then it's different.
All right. What are the difficulties with third-party placement now compared to before?
Emily, what about this memo that came out on February 22nd, and it was published the same night, though, on that memo, particularly addressing the third-party placement? We were already seeing a lot of RFEs and denials on that. What is this memo did any different than what was occurring in the field, Emily?
Yeah, I think for the most part, it actually put in writing what we were already seeing the trend was in adjudications. It's becoming, up until the memo was issued, it was becoming more and more difficult to get an approval without an end client letter. And more questions on the employer-employee relationship. It was just becoming more difficult for third-party placement. And I think that now that we have this memo, we can see why. That's what they were planning all along. This memo does go a little bit further in that it discusses looking backwards during the previous validity period to see whether the status was maintained during that time. Was the payment done properly? Was the employer-employee relationship maintained during that time? Was an amendment filed on time? And we are seeing requests for evidence that do specify exactly those points when they see something unordinary, out of the ordinary in the documentation that's submitted. Other than that, I think now we're also seeing that it might not even be enough to have just the letters. We're seeing requests for the contractual documents for the whole chain, in addition to letters. They're specifically asking for that, which we knew in the memo they were pointing to that. We weren't sure how far they were going to take it, but we are seeing in some requests for evidence that they are asking you to prove all of the contracts, not just through letters.
Shiva is asking the question. You can't read his name, Shiva. I can proudly say that. It's in Telugu script. Does working on EAD count towards the H-1B total 6-year period?
No. I'm not sure if that's an H-4 EAD.
H-4 EAD he meant.
Yeah, and the H-4 EAD. So yeah, the EAD itself is not a status. It's the H-4 that's the status. And H-4 time does not count towards the H-1B time. The only ones that count are L-1 and H-1 combined for either the 5-year limit of L-1B, 6-year limit of H-1, 7-year limit of L-1A. But H-4 and L-2 time do not count towards those limits.
My wife's H-4 visa got stamped, and the name is given as FNU, first name unavailable, given name and last name. It does not reflect the proper name. Will it cause any problem in traveling? This is a question from Nitish. Yes, sorry. I don't think so it will cause any problem in traveling, because normally when you travel, you do meet with an official. That person can be able to determine whether you are the proper person that is being prescribed on the passport or not, and you are the proper person who is in the I-94 or not. It's easy to explain a person. And names get confused a lot of times, particularly when Indian nationals come into this country, and the British people put the names differently, the English people, the Europeans put the name differently, Indians put the name differently within India, and there are separate, each state has a different way of putting the names. In fact, my own name got messed up. When they asked me to put what is my first name, what is my middle name, what is my last name, back in Andhra Pradesh, the way we write is that the family name we write it as first, which happens to be Rahul, it happens to be my family name, Venkat happens to be my actual name, Reddy happens to be my middle name. Everything got messed up. I'm still living with it. So it won't cause much problem, particularly when you're traveling, when you're going for stamping. But we did notice that when you're applying for the license, we are noticing a lot of problem, because when the name doesn't match the I-94 and passport, they're doing a lot of trouble there. Sometimes to avoid that, we are telling people to just get an official name change, going to the local courts here so that you resolve all the issue. But as far as the traveling and stamping is concerned, we haven't noticed any problem when the name has been done here and there.
All right. We have a question about the validity of an approved I-140 once you move to the new employer. Can you use that to keep getting H-1B extensions? How long? What if the previous employer withdraws the I-140?
Good question. On January 17th of 2017, new regulations were being issued. According to the regulations, if your I-140 has been approved for more than 180 days, and if it's been withdrawn after January 17th and after 180 days, it will not have any impact whatsoever at all on your H-1B extension, on your H-4 EAD. That means that even though the I-140 has been withdrawn, you can file the H-1 extension, you can file the H-4 EAD, you can keep changing from company A, company B, company C, use the same company A's I-140 if the I-140 has been approved for more than 80 days and withdrawn after January 17th of 2018. You can still port the date from the withdrawn I-140. Even if it's been withdrawn by company A, you can port the date later on if it's been withdrawn after January 17th of 2018. So please note that. There are a lot of rumors saying that they can withdraw, but it won't have any negative impact on your H-1B or H-4 EAD. That's all you need to understand. But please remember that it is the January 17th, 2017 that is the deadline. So if you had a previous I-140 that was been there, you did not ported the date into your new I-140, and if it is withdrawn before January 17th of 2017, you might be out of luck in porting the date. you might be out of luck in extending the H-1B based on the previous I-140.
All right, we have a question about OPT ending in August and H-1B being filed in April. What happens after August? So there are a couple of different things, and it all depends on if the H-1B is selected or not. So assuming that the H-1B requested a change of status that is required for the cap-gap extension to exist, once the H-1B is selected, you automatically get an extension of your OPT from August 2018 to September 30th, 2018. That allows you to continue working while you're waiting for your H-1B to kick in on October 1st. Now, the cap-gap extension, it is automatic. However, you need to document your continued employment authorization by obtaining a new I-20 from your school. That can be done by showing them the H-1B receipt notice. Now, what happens if the H-1B is still pending on October 1st? As I said earlier, you do have to stop working at that point because the cap-gap extension ends on September 30th, regardless of whether the H-1B is still pending or not. If the H-1B gets denied before October 1st, then that cap-gap extension ends at the time of denial as well, and the 60-day grace period kicks in.
Aarti has a question, namely that, do you think HR 392 bill will pass? I hope that it passes. It definitely relieves the Indian nationals' misery. I hope that it passes. But Aarti, I have to give you the realistic picture though, that the Congress has not passed any major legislation, immigration legislation, from the past 35 years. From past 1985 was when the major immigration legislation was passed. This 392 bill is a little bit more comprehensive immigration bill. It's not just only taking the per country quota limit off from the employment based. It is reducing the overall immigration by 25%. It is taking the diversity visa off. It is taking some of the family immigrants off. I'm not going to comment about the other things. With regards to the employment based, I definitely would like the provision of taking the per country quota off, which is going to be good for Indian nationals. I don't understand why they discriminate based on the country of birth. But it has a lot of other provisions in there that a lot of other Congress people are not supporting it. And any major immigration legislation is supposed to be passed with a bipartisan thing. Even though it is a bipartisan in the House of Representatives, I don't see much support in the Senate for the HR 390 by the Democrats in the Senate. So the probability seems to be very less, but I hope that the provision for per country quota is being taken off. Whether it's HR 392 or any other bill, I like that per country quota to be off.
Anu has a good question about what can you do if your I-140 is approved but your employer is not sharing it with you? How can you get that documentation? You can do it. You have to file a Freedom of Information Act request with USCIS, and they will send you the I-140 file, so you'll have that documentation. Takes probably a good 6 weeks to much longer than that, 6 months maybe. But you absolutely can do that. You go to uscis.gov and look for FOIA, F-O-I-A, and you'll find instructions there on how to do it.
It's a fairly simple form. You don't have to hire a lawyer to file a free. We don't recommend, because you can't mess that form even if you want to. So there is not much information that is asked there, just more your personal information. They do provide, it's taking about 60 to 90 days, I would say, fairly. And anybody who don't have an I-140 approval in their hand, we strongly recommend to file it. You can request your employer. While you request your employer, you can file this one. And when you file this Freedom of Information, this is confidential. This information will not be released to your employer. So we recommend that if you don't have an I-140 approval, you do file a Freedom of Information, as Emily has pointed out.
Let's see. I think we're getting a lot of repeat questions right now. One of the ones we haven't addressed yet, I've seen multiple questions about it, is what do you think will happen with multiple filings in the H-1B lottery, meaning people who are filing more than one petition in the lottery with different employers.
Drink, drive, go to jail. File duplicate, go to jail. That's the simple word that I will say. If you have filed a duplicate application, I would recommend that you contact a criminal law right now. We have been recommending so many times, don't file duplicate applications. They come with different excuses, this and that. If you are worth, there's one guy who says, I'm filing 6 H-1B applications. Wow, that looks too fraudulent to me. If you are worth to have a 6 job offers that will wait until October 1st, I don't think so H-1B is a proper visa for them. Mm-hmm. There's another visa called O-1 visa. Just because you are well caliber doesn't mean that you will be eligible for H-1. There are other visa called O-1. There is no numbers for it. If you have such worth, you might want to apply O-1 visa, which doesn't have any number limits.
All right. Well, I think that's most of the questions I've seen for now.
Thank you guys for coming and joining. The next week we'll have at Tuesday at 5 o'clock. Thank you guys for joining.
Thanks for joining.